Hi, I'm John Dearie, and we are delighted that you've taken a few minutes to watch our new series, which is Face to Face, in which attorneys in our office who handle specialized areas of accidents we'll have a discussion with. At the end of the day, hopefully, that you will find it informative, and if you are a current client or perhaps a prospective client, you will learn a little bit about the law from our conversation. And I'm delighted to welcome the person who handles our slip and fall department and many cases in that general area, Casey Fundero. Casey, delighted to see you.
Thank you, John.
So we have a general area of accidents called slip and fall and trip and fall. What's the distinction there between them?
Well, the area of slip and fall and trip and fall actually, John, fall under the heading of what's called premises liability. A slip versus a trip versus a loss of balance is what we're talking about. You slip, you feel a substance, it slips. You feel a trip, you catch your foot on something, that's a trip. You go to put your foot down on something and it's not there, that's a loss of balance. So in premises liability, usually one of those three things happens. It's called mechanism of injury.
What are the kinds of areas where perhaps there is a defect that causes a slip and fall accident to occur? What are some of the more traditional ones?
Well, the traditional defective conditions that you see really fall under two different categories: outside and inside. Okay. Inside cases usually are slippery floors. We handle a ton of cases here in the 5 boroughs involving staircases in apartment buildings where they're left dirty, or they're left with debris, or they don't meet code. A lot of people fall down these stairs. Outside, you have sidewalks that can develop cracks or something else. And under the law that was changed in the last 10 or 15 years, it used to be that you had the city responsible for them. But the city changed the law and they made the abutting landowner responsible for the sidewalks. Now, once you move away from the building, what you see that the city has responsibility beyond the sidewalk. And once you get into, for example, the curb, a lot of people don't realize that the curb isn't the abutting landowner's responsibility. It's part of the roadway, and that would be part of the city's responsibility, or the New York City Department of Transportation, which is a municipal agency in the city of New York that handles the maintenance of roadways. You have roadways, you have sidewalks, you have other exterior areas. For example, you might have a scenario where you have a sidewalk near a tree well. That's another entity. New York City Department of Parks and Recreation would be the entity that controls that, and they would be responsible. You have sewer grates. New York City Department of Environmental Protection maintains them, and the New York City Department of Design and Construction designs them. So these are all entities that you have to be aware of. These are all entities based on the nature of the defective condition outside. You have to put them on notice, which I know is a question you're going to ask later on. But in summary, you have two areas: interior defects, exterior defects, and myself and our firm have extensive experience in those areas.
You mentioned about the inside. I know you spoke about and touched on the stairways where there are so many apartments, obviously, in the city, and people going down in debris or a damaged stairway of some sort.
Yes.
There's also one that I was thinking about, and that is in stores. Often people are shopping in aisles there with their shopping carts and so forth, and wind up slipping on some kind of a liquid. That is a fairly common experience also.
It happens frequently, and we have many cases involving that situation. When you have a situation like that, liquid, water, grease, or something else is referred to technically as a transitory substance, and those are specific kinds of cases that need to be handled a certain way, because it brings into the two areas that I know you're going to ask me about, which is notice. You have to, either the defendant landowner or the store has to know that the spill is there. They have to be told, 5 minutes before the slip, there's a slip, there's a spill on aisle 5, you need to fix it. Well, that's one way of proving it. Then there's the way of proving it, which is called constructive notice. Constructive notice means that they should have known that it was there. Well, how do you know that? You look at the substance, and it's got dirt in it, and it looks like it's been there a long time. So if there's some type of circumstantial evidence that the defective condition in the form of water or transitory substance has been there a while, you can prove constructive notice. There's another area of the way you can prove these types of transitory conditions is what's called a recurrent dangerous condition theory. And you don't even have to show that they knew about it that day. You don't even need to show that they knew anything about this defect. But if there was such a recurrent business practice where over a long period of time they were engaged in certain conduct, that they would either know or should have known that something that they were doing was creating a dangerous condition, then that's another theory upon which you can show liability of a landowner or a store owner as it relates to liquids or transitory substances.
You know, you mentioned something before, and some of our viewers may recall, I was in the state legislature for 20 years, and the only reason that I mention it is that all during the time that I was there, from the early 70s to the early 90s, is that the issue of the city being primarily responsible for the condition of sidewalks, and hence if someone tripped over an uneven sidewalk, tripped over, for example, an elevated flag, which is, I believe, what those concretes are called, because of raised tree roots, or any of the kind of other conditions, cracked or depressed sidewalks, the city was primarily responsible. And as we're now coming to the end of the Bloomberg administration, and he will tout many accomplishments, I would have to say one that basically slipped by the legislature to a great extent was making the city not primarily, but basically secondarily responsible for injuries that occur on the sidewalk. It is, as you mentioned, so in other words, you have an apartment building, or you have a commercial store of some sort. It is their responsibility if the crack or depression or defect that causes an injury is in the footpath of the sidewalk outside of their property.
Right.
Is that essentially?
That's right. Not the curb, though. Like I said, that's
not the
DOT.
curb, as you said. That
Right.
gets into the DOT.
Right.
There are exceptions, though, that's very important, and as the law was enacted for the protection of property owners and homeowners in particular, 1 and 2 and 3 family homeowners, if that same condition exists in front of someone's 1, 2, or 3 family home, the city remains the primary responsibility as opposed to the homeowner.
Yeah,
that's
and
an interesting distinction.
It is very interesting, and there's a lot of law that talks about, you know, what's a 3-unit building, what's a 2-unit building, is it a residential purpose, is it a commercial purpose? Because what they were attempting to do is say, well, if you're making money, then you need to be responsible. If you're a resident, then we're gonna still pick up the tab on that maintenance.
Let's talk briefly about the issue of the statute of limitations, which we always include in any of our face-to-face discussions. So it is important. For a slip and fall accident or trip and fall, what is the statute of limitations?
It's 3 years from the date of the accident. You know, it's
3 years, meaning what has to happen within that 3-year period?
Well, within 3 years, you have to file papers in court. You have to file what's called a summons and complaint, which is a short statement that outlines when the incident occurred, how, etc., so that the defendant has an opportunity to respond in writing. You have to file it and then serve it with the defendant. The statute, the summons and complaint has to be filed within 3 years. It doesn't necessarily have to be served within that time period.
We mentioned about being out on a sidewalk. If someone tripped in front of a person's 1 or 2 or 3 family home,
Right.
and the city was primarily responsible, that statute of limitations changes dramatically, doesn't it?
It does. The statute of limitations under the general municipal law is 1 year and 90 days. However, the city of New York and the general municipal law as a legislative enactment had put within it conditions prior to you being able to file a lawsuit. Under the legal jargon, it's called a condition precedent. One of those condition precedents is what they say is filing a notice of claim, which in essence identifies where the incident occurred, et cetera. So it provides the city an opportunity within 90 days, it has to be filed, to investigate and see if there's merit to it.
What happens if someone comes to you, Casey, and the accident occurred 100 days ago? What happens? And the city of New York or some other municipality or the transit authority, it happened on a subway, some other entity as the defendant that requires a notice of claim, but now you're beyond the 90 days. What happens?
Well, we have a lot of experience with that type of thing because people, they don't know. It's 90 days, and 90 days goes by very quickly. If there's no reason other than you just didn't get to an attorney in time, more likely than not, it may be too late. There are exceptions, however. For example, if a child was injured, well, they're a minor, so really they have until they turn 18 plus 90 days to file the claim, unless, for example, you go to a lawyer and the lawyer takes the case, and at that point the clock starts to tick. So once the lawyer takes that case, he has to get that thing filed. There are circumstances where a late notice of claim can be filed, but it's limited. We've been successful though on it, and depending on the significance of the injury, we'll always look at a case like that and make a decision whether we can help you. We always want to help people in that circumstance.
What about a very classic kind of, as we get into a winter season, you have cases that involve snow and ice, and someone is injured as a result of walking where there may be a pile of snow and the ice is accumulated. How are those cases analyzed?
Well, one of the things about the city of New York, and it's a good and a bad thing, is that they've spent a great deal of time enacting regulations and rules that define different aspects of what you're supposed to do, what your responsibilities are as a landowner or a tenant or whatever it may be. And it's helpful because you can look at it and say, what am I supposed to do? The New York Administrative Code defines that a landowner has a responsibility to remove snow within a certain period of time once it falls. Once a snowstorm stops, they have a certain period of time, and it doesn't include at night. And we don't need to talk about specifics in terms of the times, but basically, we had so many phone calls after the serious storms a few years ago.
Sure.
After Christmas, when we had that big snowstorm, people called and said, well, I slipped and fell on a subway platform in the middle of the storm. Well, the law says if you're in the middle of the storm, they don't have an opportunity to clean it up, right? So they have to have some bit of time to clean it up. But the short answer to your question is there are rules about it. We understand these rules, we appreciate these rules, and we've recovered a lot of money for clients on snow and ice cases.
You mentioned the phrase prior notice. What does that mean?
Well,
and is that important?
Well, we talked a little bit about that before. Prior notice means that a landowner or someone in control of what we call premises has to know about the condition for them to be responsible. And what we talked about, actual notice, right? Someone told you. Constructive notice, you should know. Look at it, it's a hole or a brick that's been out for 15 years, or like I said, the recurrent dangerous condition. It's kind of a precursor to responsibility, because I think the law recognizes that if a landlord or a landowner is in the dark about a particular subject or a defect, well, should they have been? And they basically look at it in that fashion. So they need to know about it in some way, for the most part, to have a legal responsibility for the defective condition.
Someone wants to get a hold of you, Casey, and might, as a result of our face-to-face discussion here, have a question or perhaps a potential case want you to think about. How's the best way for them to be in touch?
Well, you can always call me, Casey Fendero, through the 1-800-I-AM-HURT hotline. I'm available in the Manhattan number 212-980-0404, or feel free to email me at the email address C as in cat, CF, F as in Frank, at johndeary.com. That's C as in cat, F as in Frank, at johndeary, JOHNDEARIE.com. Must be a client calling right now.
Somebody called right away.
Right on.
Thanks. Casey, thanks
Okay.
very much, and appreciate your thoughts.
Thank you. Okay.
Well, thanks very much for watching our conversation on slip and fall accidents with Casey Fundero. Just to remind you, feel free, we have a brochure on slip and fall accidents. Free, we'd be delighted to send it to you. Many of the topics we discussed are touched on in question and answer format. Just send us an email or at info at johndeary.com, and we'll be delighted to send it along to you. Just tell us where. We can either email it or send it to you in mail. Thanks very much, and hope you learned a little bit and got a sense as to how these cases are handled. Thanks again.